This is well, actually, we have two motions. We have the defendant's motion to modify parenting time, and we also have the plaintiff's motion for de novo review. I think we'll take the plaintiff's motion for de novo review first. I have read the motion, the response. I've read the transcript. There was a order entered prior to this hearing that indicated that the de novo review would not consider any additional evidence that was not available at the time of the referee hearing. That was not available at the time of the referee hearing. And that the parties, if they believed that there was evidence that was available and that they wanted to present to the court, that they would inform the court at least 7 days, I believe, before the hearing. And I have not received any information that would lead me to believe that that's the case. Ms. McLean?
Thank you. And I didn't think that I would need to do that because there hasn't been anything new except what was presented beforehand. Now, that being said, the concern that my client has is that he was self-represented at the time. And what's happening right now with the defendant.
All right, let me just stop you a minute because I had a very specific question. So, Ms. McClure, how about from you? Is there additional evidence that you wish to present?
No, Your Honor.
Okay. All right. Then the court is prepared to render a decision on the de novo motion. The legal standard for custody modification requires that a parent seeking to change custody must first establish either proper cause or a change in circumstances in the child's life since the last order. It's a threshold requirement. And the court finds that there are sufficient allegations, if proven, to support the court looking at custody so that there is proper cause or change in circumstances or allegations that the defendant has failed to provide basic hygiene and care, that the defendant has left the child unsupervised, that she's not participating in the autism therapy, failing to engage with the child's educational needs, not seeking medical care regarding lost classes, that there was a very recent domestic violence case involving the defendant, that there's been a significant change in the child's living situation. And this is all with a child who has autism and requires 24/7 care. So again, I'm not finding that any of those allegations are true. I'm simply finding that they're sufficient for the court to have a look at this. So the court will refer this to the front of the court for an investigation regarding custody, parenting time, and support. Moving on to the motion to modify parenting time.
I think, and these issues are clearly tied together, and if the court is referring this for a review of parenting time, it will be addressed with the front of the court, I assume. But at this point, the biggest issue has been that pursuant to the judgment, the plaintiff, it says the plaintiff shall attend up to 2 ABA appointments a week. It doesn't say anything about when and how and where. And ABA therapy can occur anywhere. I confirmed this I had a long conversation with the ABA supervisor about this child, this case, and what he needs. And it's likely that his at this point, he goes for several hours, 4 times per week. It's in home or wherever the parties want it to be. It can be in either party's home. And the plaintiff has insisted that it continue to be only at the defendant's home, even when he goes. And so he's making all these allegations about her and then insists on being in her home for this ABA therapy. The therapist, I will say, has noted neither of the parents have complained about each other. She did note that the defendant's mother had said horrible things.
I'm just going to object to any of this hearsay. It's hearsay.
Understood. So it was everything that was in the plaintiff's motion.
I would agree. I agree, and I don't want to get too far in the weeds in here because, like I said, I spent a lot of time yesterday reading the motion and the response. So,
right. So, and again, this is the point is that the ABA therapy happens 4 times a week. My client has told me, and I have confirmed, that it's likely going to be decreasing over the next few months, especially by fall when the child starts school. And so I think it's going to be sort of impractical for the plaintiff. There might not even be 2 ABA appointments per week. But even more importantly, it is nonsensical for the plaintiff to attend ABA therapy in the defendant's home, when he could have it at his home, or he could attend it in the community. We just need to discuss that. So, I don't know if it makes sense to change the parenting time schedule exactly as I've requested at this point, knowing that parenting time is going to be reviewed and that ABA therapy is going to be changed. But I guess what we would like at this point is that the plaintiff, when he attends ABA therapy, that the ABA therapy happen in his home, or at least not in the defendant's home. That's the main crux of the issue for this morning.
All right, thank you.
My client has no problem with doing the ABA therapy when it's on his time in his home. The problem is that it's been always in her home, even during his time, and he has a right to be there and attending the therapy. So if we want to expand the times, the child can, during the ABA therapy, my client's going to be able to get the child and have therapy in his home. He's happy to do that. He can pick the child up and bring the child to his house, and he can do the therapy at that time.
All right, well, as I said, I did spend some significant time looking at this yesterday. So I will order that any ABA therapy that occurs during the plaintiff's parenting time be at his home or in the community, but not in the defendant's home. That the defendant shall not enter the defendant's home at any time. That both parties are to follow the ABA therapist's recommendations consistently. That the defendant's parenting time, during the defendant's parenting time, only she and appropriate child care providers can supervise the child, so that the boyfriend, who's part of this whole issue, is not supervising at any time. That any child care arrangements be communicated to the plaintiff in advance. And I'm not saying that hasn't happened. I'm just saying, I'm just going to clean up the order. It sounds to me like this child should be exchanged at a neutral location. That wasn't requested, but I guess I'd like to hear about what the response to that is.
Well, Your Honor, I don't, I think that these parties have actually gotten along fine. It's the third parties that have maybe caused an issue.
Okay, so you don't have a problem with or your client doesn't have a problem with the plaintiff coming to her house to pick up the child?
I think as long as he doesn't come into the home, it's not an issue, Your Honor.
Okay, then I think I've made that clear.
My client is asking that they meet at a neutral location. He doesn't feel comfortable with these allegations and everything else that's going on. He doesn't feel comfortable.
I just think that's really odd, because the plaintiff, as recently as this week, insisted on coming into the defendant's home to attend ABA therapy. She tried again to get him to agree to attend
because
ABA.
he couldn't attend.
All right, Ms. McLean, we can't all talk at once. But yeah, I given the allegations here and the tension, I really think a neutral location is appropriate. And is there somewhere that's convenient halfway between the parties that would be appropriate?
Asking him right now.
Well, Your Honor, my client doesn't have a vehicle right now, so I don't, there isn't a convenient location for
Walker
her.
Police Station. It's halfway, my client says, halfway between the houses.
Okay, all right, wait. How old is this child?
He's 4, about to turn 5, I think.
Okay.
No, he's 5. He's 5. Sorry.
Is he able to walk out the door and go to the vehicle?
Yes.
I think he is, Your Honor.
At the house?
He's not able to walk out to the vehicle by himself without having a parent walking with him because of his many issues that he has, Your Honor. He's probably functioning at more like a 22 to 23 month old.
And that's not what I heard from the ABA supervisor, Your
Okay,
Honor.
okay,
So-
all right. Yeah, this is hard. Then I guess parties can meet halfway in the driveway or on the sidewalk, to exchange the child. So it's not in the house.
Okay.
Okay,
So she's gonna walk the child out to the end of the driveway and he'll pick the child up from the end of the driveway.
yep, that way there's a parent with the child all the time.
That makes sense.
The court will order that our family wizard be used for all parenting communications. I have an order, kind of a standard order that I use. We'll send that to both attorneys to have a look at to see if you want to make any modifications, just because there's all kinds of options in there. But I do want these parties to use our family wizard. And I do also want to order a safety assessment of both homes, just to make sure that they meet the needs of a child with autism, because it is a little different than perhaps a standard front of the court investigation. So I'm going to include that in my order of referral.
Okay, thank you, Your Honor.
And then I'll have the parties split the cost of the referral.
The $300, $150 a piece.
Yes.
And when does it need to be paid by?
The front of the court contacts people. I think it's within 7 days.
It's 7 or 14.
Yeah.
The other thing is, if one person ends up paying it all, because sometimes a party won't pay it, and then it will get just basically the order of referral is set aside or it's vacated because of lack of payment. If, for example, my client ends up paying the whole thing, would he be entitled to be reimbursed the $150 down the road?
Yes.
From
Yes.
Okay.
Yes. Yes.
I want to make sure that's in there.
Yes.
Okay.
And is there anything further?
I don't believe so. I think you covered it all. Thank you, Your Honor.
All right, the court will make the referral to the front of the court, but Ms. McLean, I'll ask you to prepare the rest of the order.
Happy to do so. Thank you, Your Honor.
All right, thank you. We're adjourned.
Thank you.